So I was informed that some information was being sought as to our procedures in the Miami-Dade State Attorney's Office as it relates to the direct filing of juveniles to the adult court system, specifically the criteria that our office uses, how we evaluate these cases, how we make those decisions. So I'm here to speak a little bit on that, answer whatever questions you may have as well. I wanted to begin by kind of setting forth our general philosophy. The philosophy of the state attorney, Ms. Rundle, is relative to our size in Miami-Dade County, being the largest county in Florida. We really do direct file an extremely small number of juveniles. And that is in keeping with our general philosophy that direct files be reserved for really the worst of the worst crimes. Legally, Florida law would allow us to send many, many more juveniles to adult court than we actually send. But our office has come up with and developed over the years a set of criteria that we look at every felony that comes in. And a juvenile must meet our criteria in order to be even considered for direct file. And I have those here, and I'll just list them for you real quick. And again, this only applies to felony cases, whether a juvenile is going to be potentially sent to adult court. So the first criteria is if the juvenile is charged with an extremely serious crime, including certain crimes of violence, and crimes in which the juvenile was in the act of committing the crime with a weapon or firearm of some sort. Gun violence in particular is taken extremely seriously by the state attorney. Pretty much any crime of violence committed with a gun is going to get reviewed for direct file. And I want to emphasize also, when our office reviews a case for direct file, when it comes into the state attorney's office, reviewing it for direct file does not mean it's going to be direct file. The vast majority of cases do not end up getting direct filed. However, when the juvenile meets these criteria, it's our red flag, so to speak, that there could be something going on with this child. And he either is in need of additional services that can be provided by the juvenile delinquency unit, or if the crime is so egregious, he may just need to go straight to adult court. The second criteria that we use is if the juvenile is aging out of the juvenile justice system. That means a child who is 17 years old and approaching 18. The reason for this criteria is we have limited jurisdiction in juvenile. If the child is not committed to a facility, our jurisdiction over that child ends at age 19. So the purpose of the juvenile justice system, unlike the adult system, is not to punish. The adult criminal justice system explicitly says in the statutes, the primary purpose is punishment. Juvenile is different. The primary purpose is rehabilitation. So if we have a child who is almost 18, approaching 19, not in a position where he or she could receive sufficient services in juvenile court because they're just not going to be around long enough, that is one of the criteria that we're going to have to look at that case and say, okay, is it feasible to keep this child in juvenile because we have so little time with him? We also have to consider, once we lose jurisdiction over a case, if the child turns 19, we lose that case forever. And if there is, for example, a victim in that case, a victim who's owed restitution of some sort, for example, we don't want to just lose jurisdiction over that case. So we have to look at those cases very carefully when we're about to lose jurisdiction. A third criteria is if the juvenile is currently on probation or has previously been on felony probation. This tells us if a child is currently on probation, that means they've had a felony crime, say a grand theft of a vehicle, stole a car, was put on probation, and went out and stole another car. Okay, so clearly something's not going on correctly with that child. The fact that he's currently under the supervision of the Department of Juvenile Justice, but has still committed a new felony, that's a child we now need to take a look at. Same thing if the child was previously on probation and now is picking up a new crime. Even if he's not on probation anymore, it's obvious that something did not go right during the first time that child was on probation. So we want to take a closer look at it. And I, again, emphasize, it doesn't mean we're going to direct file the kid. In all likelihood, a child who is on probation for a grand theft of a vehicle and picks up another grand theft of a vehicle, although we may review it for direct file, that sort of case is not the type that we are actually looking to direct file into adult court. That's the type of kid that we're trying to help. We want to get him services. And the final criteria on our list is if the juvenile is charged with a third nonviolent third-degree felony and has at least 2 other open third-degree felonies. So going back to the simple example of a grand theft vehicle, very common charge for a juvenile. If a child is arrested for a grand theft motor vehicle, he gets arrested, we keep the case in juvenile court. He gets arrested a second time for the same crime, we still keep the case in juvenile court. He gets arrested for a third time for another grand theft vehicle while those other 2 cases are still open pending. Now we're going to review that case for direct file because this child is telling us something is going on with him or her, and they need more help, more services, and there's something going on. Now, once a child is identified as being reviewed for a direct file, it goes through a fairly extensive process where an evaluation is done, psychological evaluations are done, and it culminates in a staffing. And at that staffing, he's represented by his attorney, the public defender, or whoever else may be representing him. And the usual result of these staffings is most of the cases will plead. These cases that we're reviewing for direct file will usually close to some sort of a plea agreement. A very small number of them, of course, are going to get direct file into adult court. These are going to be your most serious cases. These are your homicides, your attempted homicides, armed robberies with firearms that get discharged. Those are the sort of cases we take very seriously, sexual batteries. If you look at our list of cases that get actually sent to adult court, you're going to find really they are the worst of the worst at what comes into the juvenile justice system. But the vast majority, and I'm talking about out of the hundreds of cases that we do review, the vast majority do stay in juvenile court, even after the direct file review process. The direct file review process is not intended to just fast track kids to adult court. It's intended to try to get kids who clearly are having some sort of issue in their lives or in their homes or in their school or somewhere to get them whatever help or services they need so that they don't do it again. That's the bottom line. We want kids to stop what they're doing now because we know from experience and history, it starts as a kid, it works its way up and gets worse as an adult. And that's what we want to stop it in juvenile court if we can. We can't save every kid, we know that, but we really try. We do our best to try. And we don't always get it right. We don't claim we do. It's very much a, it's not a science. 2 + 2 equals, irredeemable. It's very much based upon our training, our experience of myself, of my division chief, Mr. Bass, in juvenile court. He's been doing this for a very long time. And many factors go into these considerations. The victim's position, of course, we always have to listen to the victim's position on these things. But at the end of the day, we make the best decisions we can with the information that we have available to us. And I think the state attorney would be proud of the fact that she sends so few of the kids in our community to adult court, because we don't regard that as a victory. We regard that as a failure. When a kid has to be sent to adult court, that's a failure. We don't like that. So I think that's all I have. If there are any questions. Yes, sir.
Yeah, I appreciate the presentation. I guess we're dealing with a situation where we've got a lot of juveniles who are acting in such a way they don't necessarily rise to adult crimes. I mean, although we've had a few that have certainly risen to felonious assault or potentially, and again, I'm not a criminal lawyer, so I don't know what brings that. What are the ramifications to a child who gets put into the juvenile system? Suppose they're prosecuted as a juvenile. We're really trying to educate our residents and their kids as to what the possible ramifications are to them going forward if they've been entered into the system and now they've got to deal with juvie court and everything that goes along with that.
Sure. Well, unlike adult court, we don't send children to prison for years and years, but it is conceivable any child charged with a crime in juvenile, a felony, could be committed to the custody of the Department of Juvenile Justice. I guess that would be the most serious consequence that you can get as a juvenile, is to be committed to the Department of Juvenile Justice. And there are different levels of commitment, from low risk up to maximum risk. And maximum risk would be the highest level. And again, you're going to probably find the kids who were kept in juvenile but committed to the maximum risk juvenile facilities are charged with the most likely the highest level felonies who were very, very close to being sent to adult court, but we just decided not to. But the challenge is that the jurisdiction of, if a child is committed to DJJ, the jurisdiction is still very limited. It goes up to age 21. It's a little better than if they're not committed. If they're not committed, as I said, it ends at age 19. But if they're committed to the custody of the department, we can keep them there technically until age 21. That would be the most serious consequence. Most cases don't result in a commitment to DJJ, however. Most cases are going to be put on some form of supervision, probation, etc., and they're going to be subject to jurisdiction up until the age of 19. And the conditions of probation could be counseling, it could be anger management, domestic violence classes. It depends on the nature of the crime, anti-theft courses, things like that. Restitution for the victim, if there was medical bills or financial restitution, etc.
Do they have a record of the juvenile system?
We can't hear. You have to unmute.
What kind of record does someone take the rest of their life if they're a kid, they get arrested, sent into your system, whether it be till they're 18, 21? Is that a record that goes with them, or does that record disappear when they get older?
No, the record doesn't disappear. We certainly always have access to that record. If the child gets arrested as an adult, I can see all of his arrests that he had as a juvenile. And I can see if he had a lengthy history as a juvenile where he was getting arrested a lot and then he turns into adult and starts picking up cases, that's not invisible to us. We can still see that. And we can still consider that. For example, there's crimes that you can still be charged with, possession of a firearm by a juvenile delinquent, things like that.
But I was thinking as far as his education, as far as jobs going forward, that's going to be tough to overcome.
Well, I can't speak to that. It's possible. Juvenile court is not as public as adult court. I can say that. There are confidentiality rules that apply to juvenile that don't apply to adult court. However, if your employer finds out about your juvenile history and decides to discriminate against you or not give you a job as an adult because of it, I can't speak to whether that violates any employment laws. That's not my area of expertise. I don't necessarily know.
Thank you.
Sorry, Councilmember Laredo and then Councilmember Kaplan.
Thank you. Thank you for your presentation. I am perfectly aware that I know Ms. Fernandez run for many years. It's kind of case that you have very, very serious compared to what we are perhaps, as you know, we're having this special meeting of the council because we have a situation that it seems to be escalating. It would be as a law enforcement officer, in a way, an officer of the court. I mean, the role of policing and law enforcement is prevention. After the crime is committed and we go into the process, it's already damaged our societal fabric. So I find myself in the conflict between all these, rehabilitation concepts, and I took some notes, the seriousness of the cases, 3-time repeat. But we are, I hope, going to try to move in the direction of zero tolerance. I've been advocating it for 2 years in this community because we're on a slippery slope of people getting away with a lot of things. And I find myself, while sociologically and politically sensitive to youth and rehabilitation as a concept, it is a weak link in our policy, because if the police enforces the law strictly, then you all don't prosecute because you got a lot of other cases that are more serious. We're like going around in circles. I don't want to call state attorneys the weak link in the system, but in this case, because one could reach that conclusion, we prosecute, we arrest, we charge, and then it gets dropped off. They just come around and around. We don't have the patience to wait for 3 violations. We're a small community, as you know, and we have high standards. How do we get better in terms of getting prosecution from your office so that we can prevent this cycle of violence going forward?
Commissioner. You know, it's hard to speak about these things in a vacuum because every case is so different. You know, and I can give you cases where juveniles were arrested for extremely serious crimes, and everyone was perhaps, a lot of people might have been prepared to just give up on that child, but they turned into a success story. And so, because it's so very hard to predict and to know these things. What I can tell you is this, at the end of the day, the state attorney is always going to do what she thinks is best. And, you know, respecting the other political branch of the government, of course, but it is ultimately her role and her authority to decide which cases go to adult court. Now, if you're having an issue where you believe kids are not being prosecuted in juvenile court or cases are being dropped when the evidence is still there, again, I can't speak in a vacuum. If there are specific cases that your chief will bring to me, I can look into any individual case or any individual child. If there's a particular problem child in the community who's getting arrested a lot, I can talk to your chief about that child and see what's going on. But you know, as a general matter, we're not having just dropping cases just to drop them just because they're juveniles or just because they're difficult or just because the kid is, you know, a problem child. That's just the opposite. The more bigger of a problem the child is, the more we want to help him or her.
Councilmember Kaplan.
The answer that you just gave really responded to the question that I wanted to ask. I'm good.
Thank you.
I started saying that I respect the limitations that you have and the level of crimes that you have and the state attorney. So it's with that seriousness, concern about your workload. You do understand, however, and probably the best benefit for me is for you to take this message back to your office and that there's a conflict between social servicing, rehabilitation, social engineering, and demands by people who elected us and your office for law and order. And I don't know where the balance is, but we find ourselves in Key Biscayne at a crossroad that has never happened before. And if we don't stop it with very serious arrests, it's going to get out of hand. And if the prosecution arm is not helping us or sensitive, then we're wasting our time. Do you understand that? In the healthiest, constructive way I can, I hope you carry that back to the office so that we can work better together so that we can accomplish what the citizens want, which is tranquility, law-abiding, and safety. That's
okay.
The same thing, Commissioner.
Apologies. Councilmember McCormick had a question, I think, and then we're going to have the public. Public defender
I'd like to say that I thank Councilmember Laredo for his frankness and directness in addressing the situation and really agree with a lot of what he said. I think the only...
Yeah, I can't hear.
He can't hear me because I'm on Zoom. Can he turn up his actual computer speaker?
To the meeting?
Mike, you want to just repeat your question?
Yeah.
Sorry, what are we doing?
Okay,
Really? I use so many words, Mike. How are you going to do that?
Small words.
All right, I'm going to try to just add on to what Councilmember Laredo said.
She's adding on to what Councilmember Laredo has said.
For me, the point and purpose of having this presentation tonight was twofold. Do you want to translate that? I feel like I'm at the UN.
Can you give him a set of headphones?
Interesting. Basically what she's saying is she wants to say her purpose for
Sorry. These are actually brand new.
You hear me now?
Yes.
Okay, much better, because I don't think that the mayor can do justice to my wonderful. So
continue.
What I said, and for everyone at home, I apologize for saying it like the third time, but I'd like for you to hear. I thanks Councilmember Laredo for his directness in what he said, and I share much of his views on this subject. But the one thing I thought that I could add that would be maybe a little bit of a different perspective was, for me, the point and purpose of having you come out and having presentations like this was really twofold. One was for the benefit of our community, for kids and their parents to know that we have really serious consequences when people break the law. And whether that's being tried as an adult, if it's really egregious, or even just the juvenile justice system, that this stuff is serious. And we as a council have directed the police and the manager to be very serious about this, and to have this sort of zero tolerance policy that Councilmember Laredo spoke of. So I think it is, on one sense, important to use this meeting as a tool to educate our residents on what the consequences are. And I would say that the other goal that I had was similar to what Councilmember Laredo said, to notify your office that we are seeing a real problem here, that we have noticed. And I've been on council now, this is my 5th year, and I know I've been saying it since I was elected. It's probably one of the things I said to try to get elected the first time, that we have a problem with children on our island not feeling like they're accountable to rules or laws, and not having, and of course, I'm speaking in very broad generalities. We have many wonderful children on this island, but we have issues with the lack of respect for authority. If an adult says, hey, knock that off, instead of like, I'm sorry, and running away, we get really kind of, I'm old, so I'm going to say very fresh back talk. And it's a problem. And so as a community, our residents want to feel safe going to CVS. They want to feel safe walking their dog at night when a pack of kids come by. And so you're probably going to be seeing more people coming your way from us. And I think it's important certainly for you to execute your office the way that you plan on doing it, but also to have a little perspective of the situation that's going on here. And so those were the two goals that I had in tonight. And hopefully we've communicated it in a way that has expressed what our situation is. And also thank you for taking the time and for coming and for talking to us and for listening. So thank you.
Thank you. My pleasure.
Thank you, Mr. Dunn. Thank you very much for coming. Next we have